All right, good evening, friends. It's Erickson here again from Playa Paws Animal Rescue to finish talking to you about our recently filed federal civil rights lawsuit where we are suing the major players involved in the illegal police raid of my house and animal rescue in Puerto Rico. This is the fourth part. In the first three parts, we got up through the end of the illegal raid. So now we're starting off after the raid has happened and up to the present point. This is obviously an ongoing situation. I'm still being retaliatory prosecuted, as retaliation for filing my lawsuit back in April or May to get the cats and property back. So that's going to go on. And I actually have my next criminal court hearing on Friday, September 6th of this week in Mayaguez. If any of you would like to join me, feel free. And so now I'm going to finish up going through the rest of the criminal or this federal civil rights complaint that we filed. There's about 14 pages left of the 56. So we're right on track. So, all right. Oh yes, last time we left off where I moved to Florida and flew the remaining cats from Puerto Rico that the police did not manage to seize, flew them to Florida also. So after that, I retained a lawyer in Mayaguez to file a lawsuit to sue the police for the return of the illegally seized cats and property. However, since the police failed to notify the seizure as required by Puerto Rico's uniform law for the law of confiscations, Ley Uniforme de Confiscaciones, Law 119 of 2011, as amended, which is the due process that is due, the courts dismissed the impeachment case because the cats had never been seized as per the law, but simply taken by the police. Hence, nearly a year after the plaintiff's cats and property were illegally taken by the police, there is no legal recourse to get them back. And I want to explain this piece to you because this is, there's a lot of frustrating parts of what's happened to me here, but this is probably, from a legal standpoint, the most frustrating because it's basically saying when we sued to get the cats back, since the police illegally seized them with an illegal warrant and the police had never filed the required seizure order that they would get from the court saying we seized this property and we're seizing it as part of a criminal investigation, the police never followed the law. And so when I sued to get my cats back, the judge threw out my case at the prosecutor's demand because the police had never legally seized the cats, so I could not legally get my cats back. You want to explain that one to me? Because the police violated the law, did not follow the law, did not follow their own processes and procedures. I, as the victim, cannot use the legal process to get back what essentially amounts to my stolen property from the police, since the courts are saying my property was never seized by the police. It was taken by the police, never seized. So therefore, I cannot use the court system to get my illegally stolen, not seized property back from the police. Explain this to me. This is a big part of our civil rights lawsuit as well, demanding an injunction because the Puerto Rico law is deficient in providing a remedy for when the cops go to your house, kick down your door, and steal everything you own. And this happens a lot in Puerto Rico. So how many other people have had this exact scenario happen, especially with Captain Figueroa Andujar, who it's his modus operandi? This is what he does. He takes his drug squad with 10 to 15 armed men, kicks down the door of innocent civilians, steals everything they own, disappear, don't even file criminal charges, most of the time, like in my case, no criminal charges were ever filed. Not until 8, 9, 10 months later, after I was engaged in a lawsuit against them, calling out their illegal conduct to get my illegally seized cats and property returned to me. Then they retaliate with the full cooperation and support of the prosecutor and charge innocent people with crimes, in my case 120 crimes, that they never saw fit. Wasn't charged the day of the raid, not the week of the raid, not the month of the raid, not 6 months after the raid, no. Only out of retaliation for calling out their illegal and unconstitutional conduct. And in fact, there's a newspaper article where the daughter of Captain Figueroa Andujar, the same one with the $6.5 million jury verdict against him for doing to someone else exactly what he did to me, according to this news article and according to his own daughter, back in 2014, the captain got an ex parte order, completely skipped the legal process of going through social services when he wanted his grandchildren, his daughter's children, to be taken from her. And rather than follow the legal process of getting social services, family and services involved, what does he do? He went behind everybody's back, got an ex parte order from a judge, skipped the whole legal process, and sent his drug squad to kick down her door in the dead of night and take her children. At what point is this man going to be stopped? The $6.5 million verdict meant nothing to him because he didn't pay it. The Puerto Rico Department of Justice paid it and gave him a damn promotion in 2009. Then he goes and does the same thing to his daughter, allegedly, in 2014. Now here he was doing it to me in 2023. You think there's no one in between? You think these are the only 3 incidents, the ones that have been brought to the attention of the public? No, this is how he operates, and he's fully supported by the Puerto Rico Police and the prosecutors. And he gets away with it? Because look at what I'm going through. Most people find it's not worth it, and most people also can't just pack up and get the hell out of Puerto Rico to sue the police. And you know damn well you can't sue these corrupt thugs while you're actually living there. And look what happened to me. You think I could be conducting this lawsuit while I'm still living there? They already sent 15 armed men to illegally kick down my door in the dead of night. There's nothing stopping them from coming back and putting a bullet in my head when I'm sleeping at a later date and then claiming ignorance. Oh, we don't know. We don't know who shot her. Only 10% of murders here are solved, so guess we'll just shut the book on this one. That's how they operate. And they operate with impunity because there's never a consequence. And it goes all the way to the top. So that's what this is all about. My case being dismissed to get my cats back because the cats were never seized. Well, I'm sorry, it certainly looked like they're being seized to me when 15 armed police officers were hauling them off my property under the guise of a supposed warrant. But no, they're not seized, they're occupied. Yeah, okay. Anyway, to make things worse, Erica's lawyer warned her that if she were to sue the police for the return of her cats and property, the police would certainly arrest her. At this point, it had been over 4 months since the illegal raid, and Erica still had not been arrested or charged with anything. There was no case against her, and so she did not understand how or why she would be arrested when she had done nothing wrong. But Erica's lawyer was right. He had seen it many times before, and it is common practice of the police and prosecutors in Mayaguez, Puerto Rico, to retaliate against anyone who challenges them or speaks out against them. Nonetheless, Erica filed her case challenging the seizure, also called the impeachment of confiscation, of her cats and property, and got a hearing date for April 29th, 2024. The government asked for a continuance, and the hearing was moved to June 3rd, 2024. On Monday, June 3rd, 2024, Erica flew to Puerto Rico for this hearing, only to be told that the judge had dismissed the case the previous Friday without any hearing at the request of the government. The judge determined that since the police had never followed the legal procedure of filing the required confiscation order within 120 days of taking the cats, the plaintiff could not challenge the seizure because they were never seized or confiscated. They were simply taken by the government. Thus, the plaintiff's sole legal recourse to procure the return of her illegally seized property and cats is the equitable remedies provided by injunctive relief through this lawsuit. You have to literally make it a federal case because Puerto Rico gives you no justice, no option for justice, not even a path to take. So, thankfully, we have the federal courts to oversee this corrupt issue. Then on June 7th, okay, so my hearing for June 3rd to get my cats back was dismissed by the judge at the request of the government. Oh, and 4 days later, after making Erica fly back to Puerto Rico for the hearing that never took place to get her cats back, the prosecutor who signed off on the illegal warrant, who had been contacted by Teleonce prior to the raid on the plaintiff's house, filed 120 counts of animal abuse and animal neglect against Erica, including 57 felonies. He then demanded that the judge refuse to grant bail or bond, so Erica would have to sit in Puerto Rico jail for 6 to 12 months pending trial. Erica's lawyer for the criminal case said he had never seen anything like this, and the prosecutor clearly had it out for her. Teleonce showed up at the Rule 6 probable cause hearing on June 7th, 2024, and even though the news media is never allowed into probable cause hearings for reasons unknown to the plaintiff, Teleonce was allowed to be in the courtroom for the entire 10-hour hearing. And even though no pictures or recordings are allowed to be taken in the courtroom, the reporter from Teleonce took a picture of Erica in handcuffs in the courtroom as she was being led to jail. No other news channel was at the hearing, only Teleonce. During this Rule 6 probable cause hearing, Ramos testified that he had taken the complaint of Maria Gonzalez accusing the plaintiff of animal abuse on August 25th, 2023, 2 days after the false and defamatory news stories aired by Teleonce. Ramos said that other than taking Maria Gonzalez's complaint, he did no investigating whatsoever before taking out the warrant. The warrant reads as if it was taken directly from the Teleonce news stories rather than from an actual police investigation. The warrant mentions that their investigation showed that the plaintiff forged vet records and cat health travel certificates. This was an allegation made by Jorge Gonzalez, who was interviewed by Teleonce. He is the one who invented this allegation. However, when Erica's lawyer asked Ramos what evidence he had that she forged vet records and health certificates, he said an unknown person had shown him a screenshot from Facebook. He said he did not have a copy of the screenshot, did not know who showed him the screenshot, nor did he remember where on Facebook the post was made, nor by whom. Yet this felonious accusation was contained in the probable cause section of the warrant, along with many other allegations that Ramos testified that he had never investigated or corroborated. At the same hearing, Dr. Luna testified that she could not state that the plaintiff had abused or neglected any of the cats at the animal rescue. Dr. Arce did not show up to testify at this hearing. At the end of the hearing, the judge stated to the prosecutor that none of his witnesses could state that the plaintiff had abused or neglected any cats, and so he did not see proof to sustain the 120 charges filed against the plaintiff. Then, to plaintiff's complete shock and disbelief, the prosecutor held up a stack of random papers and demanded to the judge that in Puerto Rico, it is illegal to even possess a sick or injured animal. And so they had to arrest me. With no thought or hesitation, the judge instituted all 120 charges against the plaintiff, including 57 felonies. Erica was handcuffed, put in leg shackles, and hauled to jail. Her bond was initially set at $58,000, but her lawyer got it reduced to about $27,000, and she posted a non-refundable bond of $2,700 to get out of jail. After the June 7th hearing, where Erica was charged with 57 felonies and 63 misdemeanors for animal abuse and neglect, she had to go back to Puerto Rico for a preliminary hearing on August 12, 2024, where once again the prosecutor had to present enough proof to substantiate the charges. At this hearing, Sergeant Ramos changed his testimony to completely contradict his testimony at the Rule 6 hearing. This time, Ramos testified that Captain Figueroa Andujar had taken Gonzalez's complaint and that he had thoroughly investigated her complaint and even went and interviewed the other neighbors. He could not remember when or where he interviewed these other neighbors, and he said he didn't think this information was important. Sergeant Ramos also testified that he had been a police officer for 29 years in Puerto Rico and that he had never taken out a warrant ever in his career other than in this case. All the facts and testimony point to the fact that it was actually Captain Figueroa Andujar who took Maria Gonzalez's complaint and was involved in getting the warrant that Ramos was only involved in at all because he was one of the only police officers who spoke English in Añasco. As Ramos himself testified, he was chosen to serve the warrant on the plaintiff due to his ability to speak English. Evidently, the police and prosecutor are trying to avoid any mention of Captain Figueroa Andujar's involvement in the illegal raid because he has a documented history of similar illegal conduct that justified a jury award of $6.5 million that included punitive damages. That means to punish him for bad behavior, not just actual damages. Also at this August 12, 2024 hearing, the health department inspector, who had come to the plaintiff's house on October 3rd, 2022, and threatened to have Erica arrested if she did not let him inside without a warrant, testified. The inspector admitted reluctantly that the health department had closed their investigation into the plaintiff after Maria Gonzalez and the health department lost the lawsuit against the plaintiff in November of 2022. He acknowledged that the health department case was officially closed in January of 2023. When Erica's lawyer questioned him as to why they were at her house with Teleonce, saying that they had complaints against her when he had already admitted there were no new complaints and no active investigation, he testified that after Teleonce aired their accusatory false news stories on August 22nd and 23rd of 2023, the health department in Mayaguez had received a phone call from the higher-ups at the health department in San Juan, telling them to raid Erica's house and shut her down due to the Teleonce news accusations. Erica's lawyer asked the health department inspector if he normally sent out notices to people when they were under investigation and had complaints against them. He said yes, they always notify people when the health department was investigating by sending the person a written notice of the accusations and concerns and what the person needed to do to address the accusations and concerns. Erica's lawyer asked that if at any time between when they first received Maria Gonzalez's complaint in May of 2022 and when they participated in the raid on my house and rescue on September 1st, 2023, if they had ever sent Erica a single notice of any kind. The health inspector said that they did not. They never sent a notice. He had no explanation as to why Erica was never given any notice when it is their standard procedure to always do so. Erica's lawyer also asked if this inspector had ever been involved in a case where a person accused of having animals in poor condition, where 15 armed police officers were sent to kick down their door in the dead of night, took all their belongings, and then charged them with over 100 criminal charges. He said he was not aware of any other similar cases. So that there wraps up the facts section of our federal lawsuit complaint. That's the bulk of why we're bringing this lawsuit. Now the next section here, which is shorter, it's much shorter, this goes on to detail the actual allegations. You have to state your specific causes of action. We've explained what happened. We explained who the people are and why we're suing them. Now we describe the actual counts, the actual charges. These are not criminal charges. These are civil complaints, civil allegations for the violation of my rights. So here's where we get into the kind of legal jargon and say, okay, you just heard this awful thing that happened to me with this horrible raid and the illegal seizure of my animals. But under the law, what is the actual violation of the law that is taking place here that gives me a right to sue all these people for millions of dollars? So this is where we get into case law. So I apologize if this sounds kind of legalese, but there's not that many pages left. So count 1, illegal search and seizure. The allegations of all preceding paragraphs and subsequent paragraphs are restated and incorporated by reference as if they had been set forth fully herein. So under each charge that we are alleging, we are basically saying the same sentence every time, saying, okay, everything that we just explained, all these 46 pages here, these are incorporated into each count so that we don't have to re-explain every fact that pertains to every count that we're alleging. So count 1, illegal search and seizure. The Fourth Amendment to the U.S. Constitution provides that no warrants shall issue but upon probable cause supported by oath or affirmation and particularly describing the place to be searched and the persons or things to be seized. The bulwark of Fourth Amendment protection is the Warrants Clause, requiring that absent certain exceptions, police obtain a warrant from a neutral and disinterested magistrate before embarking upon a search. This is a case Franks v. Delaware from 1978. In interpreting the Warrants Clause, the Supreme Court of the United States has emphasized that it requires an independent and neutral magistrate to determine probable cause. The constitutional function is hindered by misrepresentations, lies, false statements, omissions, and misstatements of the law and facts necessary for a probable cause showing, or to establish that the evidence forming the basis for the probable cause was acquired constitutionally. Therefore, a seizure does not necessarily comply with the Fourth Amendment simply because it was carried out pursuant to a search warrant. The September 1st, 2023 raid by the defendants lacked a proper legal order warranting the search conducted on the plaintiff's property and the seizure of her cats and property. The search warrant, if any existed, violates the Fourth Amendment because it was obtained through intentional misstatements and untruthful information. The execution of the September 1st, 2023 raid also involves the Fourth Amendment. Defendants made the conscious decision to extend the scope of the search and seizure beyond the reasonable parameters of the search warrant and seized all of the plaintiff's cats. The actions by the defendants violate the plaintiff's clearly established constitutional rights to be free from unlawful searches and seizures under the 4th and 14th Amendments to the U.S. Constitution. Defendants' actions were motivated by a vindictive disposition or were carried out with reckless disregard of the truth and to the plaintiff's constitutional rights. The denounced actions caused plaintiff damages who has suffered to date considerable and quantifiable damages. The damages to the plaintiff were foreseeable and the intended consequence of the intentional or reckless actions by the defendants. Defendants are liable to the plaintiff. Count number 2, illegal detention and violation of privacy rights. Again, all the allegations of all preceding paragraphs and subsequent paragraphs are restated and incorporated by reference as if they had been set forth fully herein. Defendants illegally and without probable cause detained the plaintiff and paraded her in front of the press, restricting her liberty and violating her privacy rights guaranteed by the U.S. and Puerto Rico constitutions. The actions of the defendants violate plaintiffs' clearly established constitutional rights under the 4th and 14th Amendments to the U.S. Constitution. Defendants' actions were motivated by a vindictive disposition or were carried out with reckless disregard of the truth and to the plaintiff's constitutional rights. The denounced actions caused plaintiff damages who has suffered to date considerable and quantifiable damages. The damages were foreseeable and the intended consequence of the intentional or reckless actions by the defendants. Defendants are liable to the plaintiff. Count number 3, destruction of property during the illegal search. Again, the allegations of all preceding paragraphs and subsequent paragraphs are restated and incorporated by reference as if they had been set forth fully herein. During the illegal search of plaintiff's home, defendants maliciously, negligently, or recklessly destroyed plaintiff's property and killed her cat, Dulce. These actions of the defendants violate plaintiffs' clearly established constitutional rights under the 4th and 14th Amendments to the U.S. Constitution. Defendants' actions were motivated by a vindictive disposition or were carried out with reckless disregard of the truth and to plaintiffs' constitutional rights. The denounced actions caused plaintiff damages who has suffered to date considerable and quantifiable damages. The damages to the plaintiff were foreseeable and intended consequences of the intentional or reckless actions by the defendants. Defendants are liable to the plaintiff. Count 4, taking of plaintiff's property without due process of law. The allegations of all preceding paragraphs and subsequent paragraphs are restated and incorporated by reference as if they had been set forth fully herein. Puerto Rico's Uniform Confiscations Act, Ley Uniforme de Confiscaciones, Puerto Rico Law 119 of 2011, as amended, establishes the constitutional due process of law parameters to any attempt by the state to seize the property of a private citizen involved in criminal activity. If the legal requirements of the Confiscation Act are not strictly followed, then the state's action is simply a taking without due process that is constitutionally due. Defendants chose to ignore the procedure established by the Uniform Confiscations Act regarding the property of the plaintiff that was seized during the September 1st, 2023 raid, including her cats. Therefore, the seizure of plaintiff's property is illegal and amounts to a taking without due process of law in violations of plaintiff's clearly established constitutional rights. Defendant's actions were motivated by a vindictive disposition or were carried out with reckless disregard of the truth and to the plaintiff's constitutional rights. The denounced actions caused the plaintiff damages who has suffered to date considerable and quantifiable damages. The damages to the plaintiff were foreseeable and the intended consequence of the intentional or reckless actions by the defendants. Defendants are liable to the plaintiff. Count 5, malicious retaliatory prosecution. The allegations of all preceding paragraphs and subsequent paragraphs are restated and incorporated by reference as if they had been set forth fully herein. The criminal charges filed against the plaintiff are based on lies, are fabrications, lack probable cause, and were filed in retaliations for plaintiff's reiterated demands for the return of her property and cats. These charges will necessarily end without conviction. Defendant's actions constitute malicious or vindictive prosecution in violation of the Fourth Amendment. These actions of the defendants violate plaintiff's clearly established constitutional rights under the 4th and 14th Amendments to the U.S. Constitution. The denounced actions cause plaintiff damages who has suffered to date considerable and quantifiable damages. The damages to the plaintiff were the foreseeable and intended consequence of the intentional or reckless actions by the defendants. The defendants are liable to the plaintiff. Count 6, supervisory liability. The allegations of all preceding paragraphs and subsequent paragraphs are restated and incorporated by reference as if they had been set forth fully herein. The denounced practices and activities of the defendants were undertaken, aided, authorized, supervised, or tacitly consented to by the actions or omissions of Puerto Rico's Attorney General, Domingo Emanuele, and or Puerto Rico's Commissioner of the Police, Antonio Lopez Figueroa, in their failure to adequately, timely, and effectively perform their supervisory responsibilities over their subordinates. Defendants Emanuele and Lopez Figueroa have the duty to command, regulate, and control the actions of their subordinates as to prevent them from acting in a manner that deprives the constitutional rights of citizens. Each has failed in their supervisory duties and by their failure allowed or facilitated the occurrence of the denounced injurious conduct. These actions of the defendants violate plaintiffs' clearly established constitutional rights under the 4th and 14th Amendments to the U.S. Constitution. Defendants' actions were motivated by a vindictive disposition or were carried out with a reckless disregard of the truth and to plaintiffs' constitutional rights. The denounced action caused plaintiffs damages who has suffered to date considerable and quantifiable damages. The damages to the plaintiff were the foreseeable and intended consequence of the intentional or reckless action by the defendants. Defendants are liable to the plaintiff. Count 7, conspiracy to violate constitutional rights. The allegations of all preceding paragraphs and subsequent paragraphs are restated and incorporated by reference as if they had been set forth fully herein. Defendants conspired with each other to cover up their systemic, intentional, or reckless violation of plaintiffs' constitutional rights. These actions of defendants violate plaintiffs' clearly established constitutional rights. Defendants' actions were motivated by a vindictive disposition or were carried out with reckless disregard of the truth and to plaintiffs' constitutional rights. The denounced actions caused plaintiff damages who had suffered to date considerable and quantifiable damages. The damages to the plaintiff were foreseeable and the intended consequence of the intentional or reckless actions by the defendants. Defendants are liable to the plaintiff. Count 8, defamation. The allegations of all preceding paragraphs and subsequent paragraphs are restated and incorporated by reference as if they had been set forth fully herein. Claims for defamation under Puerto Rico law arise from 3 sources. Section 8 of Article 2 of the Constitution of the Commonwealth of Puerto Rico, 2, the Libel and Slander Act of 1902, and 3, Puerto Rico's General Tort Statute. Section 8 of Article 2 of the Constitution of the Commonwealth of Puerto Rico guarantees that every person has the right to the protection of law against abusive attacks on his honor, reputation, and private or family life. And that's from the Puerto Rico Constitution, Article 2, Section 8. This constitutional guarantee provides a right of action without enabling legislation. Claims for defamation encompass both libel and slander. Libel is the malicious defamation of a person made public by writing, printing, sign, picture, representation, effigy, or other mechanical mode of publication tending to subject him to public hatred or contempt, or to deprive him of the benefit of public confidence and social intercourse, or to injure him in his business or in any other way to throw discredit, contempt, or dishonor upon him. Slander, in turn, is a false and unprivileged publication other than libel, which imputes to any person the commission of a crime or tends directly to injure him in respect to his office, profession, trade, or business, or which by natural consequences causes actual damages. The boundaries of these safeguards for a person's honor and reputation are defined by the First Amendment protections for freedom of speech. The First Amendment provides, in relevant part, Congress shall make no law abridging the freedom of speech. U.S. Constitution, First Amendment. The Free Speech Clause of the First Amendment fully applies to Puerto Rico. In Puerto Rico, the tort of defamation can be either intentional or negligent, depending on whether the defamed is a private or public figure. Plaintiff is a private figure. A private figure alleging defamation needs to prove 1, the information was false, 2, the plaintiff suffered real damages, and 3, that the publication was negligent. And this is in case you're a First Amendment nerd, it's in the Ayala Jarana versus Bristol Myers Squibb Company, First Circuit, 1996. The information published by defendants Teleonce and Solimar Crespo Gonzalez about plaintiff is false. Teleonce and Crespo Gonzalez's actions in publishing false information about the plaintiff were carried out with reckless disregard of the truth and to plaintiff's constitutional rights. The denounced action caused plaintiff damages, who has suffered to date considerable and quantifiable damages. The damages to the plaintiff were the foreseeable and intended consequence of the intentional or reckless actions by the defendants. Defendants are liable to the plaintiff. Count 9, claim under Puerto Rico Constitution and tort law. The allegations of all preceding paragraphs and subsequent paragraphs are restated and incorporated by reference as if they had been set forth fully herein. The denounced actions by the defendants also violate plaintiffs' rights guaranteed by the Constitution of the Commonwealth of Puerto Rico and are punishable by Puerto Rico's General Tort Statute, Article 1536 of the Puerto Rico Civil Code of 2020. Defendants' actions were motivated by a vindictive disposition or were carried out with reckless disregard of the truth and to plaintiffs' rights. Thus, punitive damages are recoverable pursuant to Article 1538 of the Puerto Rico Civil Code of 2020. The denounced actions caused plaintiffs damages, who has suffered to date considerable and quantifiable damages. The damages to the plaintiff were the foreseeable and intended consequence of the intentional or reckless actions by the defendants. Defendants are liable to the plaintiff. Okay, so that's all the charges. And now, what are we asking for? This is what's called a prayer for relief. Wherefore, plaintiff respectfully requests this court to A, determine that the actions of the defendants were taken negligently, knowingly, intentionally, or recklessly. B, determine that the defendant's actions violated plaintiff's constitutional and legal rights. C, issue an injunction ordering defendants to immediately return to plaintiff all the property taken from her home during the September 1st, 2020 raid, including her cats. D, provide for compensatory damages in the amount of not less than $2 million as to all defendants. Provide for punitive damages in an amount considered sufficient to punish defendants' grossly negligent conduct and to deter similar misconduct from recurring in the future in an amount that should not be less than $4 million. Order defendants to pay reasonable attorney's fees, costs, litigation expenses, and pre-judgment and post-judgment interest. And G, order all other relief the court deems adequate and just. H, order this case be heard by a jury. I, enter judgment on behalf of the plaintiff against the defendants. Respectfully submitted, dated August 26, 2024, by my lawyer, the amazingly talented, intelligent warrior, Abameli Lopez Ortiz. So, that's it. That's all 56 pages. Thank you so much for viewing all 4 sections. If you haven't viewed the other sections, you can go back. I tried to chop it up in a way that kind of divided it in a natural manner from different sections. This case has now been filed in federal court in Puerto Rico. These things do not move rapidly. No court cases tend to move rapidly anywhere, really, for the most part. But like I said, I have my next hearing in my criminal case in Puerto Rico in Mayaguez this coming Friday, September 6th, starting at 9 a.m. If you're in the area or you want to attend, please let me know. You're welcome to attend, and we love to have supporters in the courtroom to observe, to be witnesses to whatever shenanigans may or may not occur. And frankly, the more people we have sitting there watching, the more likely it is that we are going to have a smooth and lawful hearing, unlike the first hearing where nobody was present on my side except one supporter, and the other side, they brought in their 9 witnesses, half the people I'm suing here. So perception and appearances do make a difference, especially in Puerto Rico. So if you can attend, that would be great. If not, I still appreciate all the support we've been getting behind the scenes, messages of support, and all of that is really great to have. And if you have any questions or comments, leave them in the comments. Subscribe to our channel. I post frequently on YouTube. Some are cute cat videos of the cats we have for adoption. Some are about this legal case or the other legal cases that we currently have that all pertain to this situation. And share our story. I can't believe that this whole horrendous situation is still being ignored by the media. The media went out of their way to create all these false stories against me, and now where's anyone where we're presenting the truth? So share it. You never know. Share it with your local news channels, your local politicians. I do not doubt that at some point, once this gets in the right hands, it's going to blow up. And I'm not saying that because I want any sort of fame, but this injustice needs to be corrected, and it needs to never happen again. And the fact that this routinely happens in Puerto Rico needs to be exposed. The rest of the United States barely knows that Puerto Rico is even part of the United States, much less what really goes on there regarding constitutional rights and their hugely corrupt police force. So we need to share the story. This should never happen again. Too many innocent people in Puerto Rico continue to have their doors illegally kicked down, their animals taken and killed, all because some busybody neighbor doesn't like their cats or doesn't like their dogs or has nothing better to do with their time than to just, neighborhood gossip and complain and bully people. So be on the right side of history, the right side of justice. I think this case is going to set a big precedent, and I look forward to getting some justice. So thank you, and we'll see you next time.